Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hi, welcome to podcast number 155. We've got three cases in this episode. One looks at reinstatement and re-engagement, which isn't a subject which comes up very often. We've got a case on holiday pay, which comes up more often than you'd think. And then finally, we've got a case on using material discovered on an employee's phone to justify their dismissal and whether that was permitted. Please don't forget, podcast is on iTunes, Mayer Brown website, YouTube, and my Twitter feed. And we're on Spotify, Google Play, and Yahoo as well. I'm sure there's some we've missed out, but anyway, plenty to be going on with. So, first case, Mackenzie and Chancellor Masters and Scholars of the University of Cambridge. This is a judicial review application which made its way up to the Court of Appeal, and it confirms a point which, to be honest, I'd understood was never really in dispute, but nevertheless it's always useful to have points like this confirmed, and an opportunity to review the workings of one aspect of employment legislation which gets relatively little attention, namely reinstatement and re-engagement provisions. The background was that the employee was employed by the university, she was dismissed in 2013, and she bought and then won an unfair dismissal claim. She asked for reinstatement back to her old job, and the university claimed that was not reasonably practicable. The tribunal did not agree with the university and ordered her that she be reinstated into her old job. This would have given her continuity of employment, but also, more importantly, $102,000 in back pay and benefits, which she'd lost by virtue of the dismissal. The university decided that it did not wish to take her back on, and instead paid her a sum of money which they said was the maximum sum that the tribunal could award against it for failing to comply with the order to reinstate. For reasons I'll explain, that maximum award was £107,000. The judicial review application brought by the employee has been around for some time because it was originally launched in 2016, but now it's made its way up to the Court of Appeal. And the claimant's argument was that she was entitled to an order from the court requiring the university to reinstate her. This was by way of enforcement of the tribunal order that had been made to reinstate her. Although the claimant stopped short in this case of asserting that she was seeking a mandatory order requiring the university to comply with the tribunal's reinstatement order, it was her case that she was entitled to such an order. So, what was the university's response, and why was it offering to pay £107,000 to the claimant instead? Reinstatement and re-engagement orders are pretty rare. I think I've come across one application for reinstatement in something like 30 years of doing tribunal work. However, under Section 114 of the Employment Rights Act 1996, a reinstatement order is an order requiring the employer to take the employee back into employment as if they'd had continuous service throughout and had never been dismissed at any point. Re-engagement, by contrast, is an order that someone is taken into a different job by the same employer. The tribunal will, when making a reinstatement order, as we saw in this case, specify the back payment benefits that would be repayable as well to bridge the gap and make good the employee's loss. Where a reinstatement or re-engagement order is made and is not complied with, then, unless it was not practicable to have the employee reinstated or re-engaged, there's an additional award payable on top of the ordinary unfair dismissal damages. Tribunal will assess an additional award, which, for an ordinary unfair dismissal claim, will be between 26 and 52 weeks' pay. As I say, this is all provided in Section 117 of the Employment Rights Act. There's nothing explicit in the legislation that states that the employee, as an alternative to an additional award, can choose to ask the High Court to enforce the reinstatement or re-engagement order. The question is there a right to that by any other legal route? Given that the $107,000 paid by the university to the claimant was only £5,000 more than the back pay which she'd lost by virtue of the dismissal, one can see why the claimant would be unhappy if she was stuck with the limited remedies available. The university's view was that the legislation, the Employment Rights Act, did not provide for any mechanism for enforcing a reinstatement order other than through the award of additional compensation in section 117. Therefore, the claimant's attempt to create a remedy in the civil courts was, they said, impermissible. The claimant asserted, both under domestic law but under section 6 of the Human Rights Act 1998 and section 13, she had such a right. In particular, she claimed that if there was not an effective remedy for a breach of the tribunal order, given that reinstatement had been ordered by the tribunal, then that would be an infringement of her right to a fair hearing under Article 6 and her right to an effective remedy under Article 13. Entirely predictably, the Court of Appeal was having none of this legal creativity. They took the view that the framework set out in the Employment Rights Act 1996 was intended to be the only remedy available to an employee who had been awarded reinstatement and then it had not been complied with. They acknowledged that talking about an order for reinstatement was possibly a slight misnomer, given that in effect the employer could pay its way out of having to comply with this order simply by accepting the initial award, which was what the university here was doing. In addition, the court said that when reading the Employment Rights Act, it was clear enough that this was the intention of the legislation, i.e. it was a self-contained and complete unto itself set of rules and remedies. There was no freestanding right to require reinstatement by another means. In any event, the Court of Appeal also pointed out there were three other reasons why it was unlikely that the claimant's view of the legislation and the remedies available were correct. First, what the claimant was asserting would in effect mean that the enforcement regime for employment tribunal orders was a mix of High Court and employment tribunal jurisdiction. Where civil courts are enabled to enforce tribunal judgments, this is done by way of an express legislative provision in relation, for example, to the enforcement of monetary awards. If a tribunal awards you damages, you can enforce it in a civil court because the legislation says so. Secondly, in making a mandatory order, the High Court would, the Court of Appeal said, have to evaluate the circumstances as they stood at that point. It wouldn't simply be a rubber stamping exercise. So this would involve, and this is my terms rather than the court's terms, some degree of review of the tribunal's decision, rather than simply enforcing it unquestioningly. For example, and again this is my example, what would happen if it wasn't practicable, if it was practicable at the time the tribunal made its order, but it had ceased to be practicable by the time the High Court looked at it. Additionally, the Court of Appeal pointed out there was no provision in the legislation to disapply the additional award. So under the claimant's view of the legislation, she could potentially get the right to a mandatory order from the court to reinstate her and keep the additional award. Thirdly, the court pointed out that Parliament and the courts have both been very cautious about requiring parties to work together in an ongoing relationship where one or other party no longer wish to be in that working relationship. Employers do not get injunctions, for example, to require employees to actively work for them when the employee's walked out in breach of contract. Typically, the employer will get an injunction preventing the employee from working for a competitor in breach of contract. That's a rather different thing. So the claimant lost her case, and I think it was very likely this was always going to happen, because had the Court of Appeal decided matters the other way, it would have been a very significant extension of the remedies available to employees. The Court of Appeal commented that their view of matters was in accordance with the orthodox view of how tribunal remedies were supposed to work, and, moreover, it was the orthodox view because it was the right view. There you go. So, if as an employer you are unlucky enough to find yourself in a position where you've lost a tribunal claim and the employee is pushing for reinstatement or re-engagement, it's worth knowing that an order for reinstatement or re-engagement is only a provisional order in the sense that you, the employer, still have a choice to make. Equally, from the employee's perspective, it is important to be realistic about the true impact of winning a reinstatement or re-engagement order. So, that's Mackenzie and Chandler, and confirmation that the only remedy for failure to comply with the reinstatement order is the additional award specified in the legislation. So, the next case is Chief Constable of the Police Service of Northern Ireland and Agnew. This is a Northern Ireland Court of Appeal case. As such, it's not directly binding on English tribunals and courts, but it is a persuasive authority. The court was asked to deal with a whole number of matters, and I'm just going to pick out two of them. Since 1998, the police constables and police sergeants covered by this litigation had been paid holiday pay on the basis of basic salary only. And we know of a number of European court cases which have now gone through the process, which establish that holiday pay needs to be calculated by reference to normal pay, which may include other elements of pay, such as overtime, if worked on a sufficiently common basis for it to be described as forming part of normal pay. There are some 3,300 police officers involved in this case, and a number of civilian employees too, who have also brought claims in the litigation based on similar issues. To give some idea of the amounts at stake, it was calculated that if the claimant's arguments in this case were right, which we'll come on to in a second, the potential damages award would be £30 million, whereas if the police authority's interpretation were right, it'd be 300,000. So there's quite a lot resting on this case. Anyway, Focusing on two of the issues that I think are of more general benefit to listeners of the podcast series, I wanted to pick up two things. First issue is to do with the circumstances in which claims can be brought where the underpayment, the holiday pay underpayment calculation, occurred at some point in the past. For the purposes of this decision, although the Northern Irish legislation applied to the case, it seems that the Northern Irish legislation and the English legislation are very similar. It's possible to bring a claim for a deduction from pay, which forms part of a series of deductions from pay, and you can bring a claim provided you commence the claim within 3 months of the final deduction of the series of deductions. That much is clear cut. However, in a case called Bear Scotland Limited in Fulton, the Employment Appeal Tribunal in 2015 decided there would not be a series of deductions such that you could then link all the underpayments together and claim over all of them, where there was a gap of more than 3 months between any of the alleged underpayments. The AT's view was that because tribunals in general have no jurisdiction to consider claims brought more than 3 months after the deduction, then an interruption of 3 months within a chain would be viewed as breaking the chain of continuity for the purpose of bringing claims. I remember at the time the decision came out, people were pretty surprised that the AT had come to this conclusion, and obviously it had a chilling effect on the volume of holiday pay litigation coming through, because in many cases employees could not point to an uninterrupted series of deductions where there was no 3-month gap between the deductions, the series, at any point. And the question for the Northern Ireland Court of Appeal, amongst others, was, is that interpretation correct? Well, the Court of Appeal in Northern Ireland pointed out there was no definition of series in the legislation, and there's not in the equivalent English legislation either. It was clear that series has some sort of reference to a temporal function. Equally, the employer's advocate accepted that for a series of deductions to exist, it was not necessary for the deductions to be what he termed metronomic, i.e. occurring with precise regularity at precisely the same point or with precisely the same gap between the various deductions. However, the Northern Ireland Court went further, and they said whether or not something was a series was a factual question. They disagreed with the suggestion that there could not be a 3-month gap between the deductions. As they point out, this would lead to the absurd conclusion that if a deduction was made from pay every 2 months, it would count as a series of deductions, but if it was made from pay every 6 months, it could not count as a series of deductions, even if in all respects it was for identical reasons and caused by an identical flaw. In essence, whether or not something was a series was a question of fact for the tribunal, and the key question was, is there a sufficient similarity of subject matter to show the necessary linkage? The court also said that a lawful payment made during a period in which there was a series of unlawful deductions would not of itself break the chain. Secondly, in the Bear Scotland and Fulton case, the court there also decided that an employee would be deemed to use up their European minimum holiday leave of 20 days before moving on to any other period of leave. Again, this approach cuts down quite effectively on the ability of individuals to bring historic claims. It increases the likelihood that there will be more than 3 months between deductions, but also, if someone has taken most of their holiday but not all of it, the Bear Scotland and Fulton approach would mean that the outstanding holiday would always be viewed as either national holiday in excess of the Working Time Directive minimum or contractual holiday pay. In general terms, an individual's rights in connection with those categories of holiday leave is rather more limited than the rights necessarily associated with European holiday leave. The Northern Ireland Court of Appeal said there was no reason to assume that employees took holiday in any particular order. They preferred to treat each day as a composite, so that each day was in effect part of the European leave, part of the national leave, and potentially part of the employer's leave allowance. This case may, of course, go to the Supreme Court, but having said that, I think the decision of the Court of Appeal on these matters is eminently understandable. First, there was, as I said a moment ago, a certain amount of head-scratching when the Bear Scotland and Fulton case came out and decided the point on the interruptions to a series, breaking the chain of continuity. I think the Northern Ireland Court of Appeal is, with the greatest of respect, they say, plainly right to say that a gap of 3 months would necessarily turn a series of deductions into something else. I don't think it necessarily follows at all. In relation to the order in which holiday is taken, I think there's little logic in saying that an employee takes one form of leave before another. Did wonder if it would make any financial difference whether an employer could specify that European holiday is deemed to be taken first. Don't forget, in the UK we have an additional cap on these claims under the deduction from wages limitation regulations in 2014. The government legislated to put a 2-year backstop, dirty word, on claims for holiday pay. There's no equivalent backstop in Northern Ireland. Just fancy that. Well, so here in the UK, where we do have a backstop, employers have a degree more protection against such historic claims. But even in the UK, the ability to bring claims for a series of deductions going back 2 years, this could make a significant difference where employees are looking to claim back up to 2 years back holiday pay. So that's the case of the Chief Constable of the Police Service of Northern Ireland and Agnew. So then we're on to the last case, and that is Garamukanwa, and my apologies if he's listening, and United Kingdom. So this is a case in the European Court of Human Rights, and although ultimately it's a little bit frustrating, but with the way they get to where they get to, I do think it's quite a helpful point for employers to have. Under Article 8 of the European Convention of Human Rights, individuals have a right to privacy and to respect for their private and family life. This is expressed to cover home life and correspondence. You may remember the Barbulescu case, which I covered in an earlier podcast. In that case, the employee was able to claim that an employer should not have access to communications at work because the employee had a reasonable expectation of privacy in relation to those communications. The background to this case sounds to be a very sad one. The claimant, Mr. Garamukanwa, or the claimant, as I'm going to refer to him now at every opportunity, had a relationship with a colleague. It broke down, and then things seemed to have gone very sour. First of all, the claimant raised some concerns about a relationship which his former partner had then formed with another employee. The person who was being complained about immediately went to her manager, promptly told her manager that she thought the claimant's conduct and email was inappropriate. The manager was shown the email that had been sent by the claimant to his former partner and went and had a meeting with the claimant and told the claimant that his behaviour was not appropriate. Thereafter, the former partner and her alleged new partner suffered a whole series of harassment and stalking incidents. The relationship with the claimant ended in May 2012, and the stalking, harassment, etc., and other trolling took place over the next year or so. The police get involved, the claimant's arrested, and during the police investigation they take possession of his personal iPhone, and on that they find photographs of his former partner's house and some paperwork indicating that he had, at the very least, connections to the anonymous email accounts that were being used to send some of the offensive emails about his former partner and her alleged new partner. This, let's call it offending material, was passed over to the employer by the police. The employer then used the offending material to dismiss the employee. The employee brought a claim for unfair dismissal. The claimant's assertion was that the dismissal was unfair because his Article 8 rights had been compromised by the employer relying on private material to dismiss him. The Employment Tribunal and the EAT both rejected this assertion. There were sufficient connections with work in any event for this not to be a matter of his private life. Emails are being sent about work colleagues to work email addresses, and in some cases the anonymous emails were raising matters purporting to relate to work. The recipients were affected at work as well. The EAT also pointed out the claimant had not objected during the disciplinary process to the use of the offending material. On that basis, the EAT said that his Article 8 rights had not been engaged, but even if they had been, then any interference with them was justified by the fact that there were other rights to be taken into account, rights for other individuals, for example. In particular, they said the duty of the trust to look after the health and well-being of its workforce. So, claimant goes off to the European Court of Human Rights, but unfortunately for him, no more success. Basically, the European Court agreed with the EAT in its approach. He could not have had a reasonable expectation of privacy in respect to the material on his mobile phone. He knew the communication that he'd sent to his former partner had been shown to her manager by the former partner, because this is what happened in May 2012. So he couldn't have had any legitimate expectation after that emails that he sent would be treated as private. On that basis, the court felt the situation was rather different from the Barbulescu case, where the individual had had a reasonable expectation of privacy in relation to the communications. So, on that basis, the claimant lost his case. Part of my frustration in this case is the claimant only seems to have thought of the argument about the breach of his Article 8 rights after he'd been dismissed. Therefore, he didn't raise the concerns during the disciplinary process against him. However, I think that the court's view that the individual could have had no reasonable expectation of privacy, well, that's compelling, and it's interesting that the Tribunal, the EAT and the European Court of Human Rights all came to the same decision on this point. Equally, I think that there are important issues here. What would have happened if there had been similar behaviour but the employee had not been put on notice that the allegations were being investigated? What would have happened if the claimant had not been told that his former partner had shown an offending email to her manager? Equally, if the emails raised criticisms about the individuals but not in relation to a work context, would that have given a better argument in relation to privacy? I'd hope not, because on the basis that material that has been obtained is relevant, you would always anticipate the tribunal would want to take it into account in whether or not the dismissal is fair or unfair. I can see there may well be harder factual circumstances where the issue of Article 8 rights will be front and centre of the legal dispute. Anyway, for now, this is a very helpful case for employers. And that's the case of Garam Mukanwa, or the claimant, and United Kingdom. So thanks very much for listening, as always. Back in a couple of weeks with podcast number 156. I'm recording this on a Friday afternoon, so I'll wish everyone a good weekend, although I suspect this won't go out until Monday. And it only remains for me to confirm that the father of all lies was not involved in any way in the making of this podcast. Thanks very much.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.